Welcome to the next session of the UK Law Commission working group to discuss the digital assets consultation paper. This working group is chaired by Iris Rad, and we'll hand over to Iris. I think you've prepared some slides for the chapters that we're going through today, and leave it to you as to how you'd like to run it, whether you want to thread the consultation questions through or if we deal with them at the end. But thank you, Iris.
Absolutely. Thank you, Joni. So I believe this is the 5th session for the digital assets consultation paper, and I thought we would go through chapters 13 to 15. I think chapter 13 was covered off a little bit already last week. Joni, I think I'm just not able to share the slides. If you would perhaps give me permission, or if you prefer to share, whichever is easier. And welcome, Nathan, welcome, Victoria. So
you should have permission now, just give it a check.
Fantastic. Hello. All right, fantastic. Let me share. Let me know once you can share the screen.
Yeah, that's great. We can see.
Okay, fantastic. All right, so should we start off with where we finished off last week, or how would you like to start? I thought perhaps I would go through chapter 13, but I think it's been covered a little bit already. So if you recall from last week, we went through legal transfers of crypto tokens, which is chapter 13. So we talked about the ways in which legal title can be acquired by original acquisition or by derivative transfer of title. So the consultation paper distinguishes between independent acquisition of title, which is where the party acquiring the right acquires a new and original right in the tangible thing. And there are 5 mechanisms set out in the consultation paper with regards to independent acquisition of title. So these include accession by natural means, and we don't have to go too deep into the technical aspects. I think we've already covered some of the consultation questions, but perhaps we can just have a brief summary. And Nathan and Victoria, feel free to jump in anytime. So accession by natural means, the person with the best legal interest in the first will acquire the same interest in respect of the second. So for example, pairs that are produced by a pear tree. So the person that has the best legal interest to the pear tree will also have the legal interest to the pairs that are produced by that pear tree. You have acquiring by accession. So the person with the best legal interest in the greater and more valuable object gets the best legal interest in the attached lesser object. You have specification. When an object is turned by labour into something else, the labourer acquires the best legal interest in the thing that was created by that labour. Commingling, I think this was also discussed last week. When you have 2 quantities or 2 types of fungible objects that are belonging typically to 2 different persons and they're mixed together, the parties will jointly have the best legal interest. So, and this will be divided in an appropriately proportionate way. And possession, which was covered in the first 2 sessions. So when a party unilaterally acquires possession of an object, they acquire the legal interest, but not necessarily the best legal interest in that object. So that's just going through a little bit. Do we have any comments there or any questions?
Just something that strikes me, because we've had the merge this week and yesterday, in fact, this specification about when an object is turned by labour into something else, the labourer acquires the best legal interest in the new thing. Well, obviously, I, as an ETH holder, didn't labour over everything, and you know, a team of developers around the world have been having input into the merge. And then there's, you know, the talks about the forks, the proof of work chain. None of that is my labour, but I could still have the new tokens in my wallet. But that's the question, are they mine?
Joni, I think in that case, just with the merge, as opposed to a fork, your tokens are still your tokens. So for every single person, and this is what's really great about the merge as opposed to like the DAO fork, where with the merge, everyone's tokens were just still their tokens. So regardless of the backend labour, there was no changes to a token. Like my ETH token in ETH1, like pre-merge, is still my token in ETH2. Nothing changed, but a fork is different. So the question is, it's a great question in regards to a fork token, like who owns it now, especially with forked NFTs. But Yeah, good question.
But the proof of work fork is only happening because of the merge.
Oh,
So
yeah,
how are they
good point.
related is my question. Yeah.
Yeah.
Anyway.
Well, who's doing the labour? Yeah.
I know whose labour. Does the fact that more of the labour probably went into the merge mean that even with the proof of work tokens, that they become properly the ownership of all of those involved in the effort with the merge? Anyway,
but
it's just a...
Yeah, okay. Yep. We can go around in circles. Yeah.
I think so, but it was just the case that came to mind as soon as you mentioned it, Iris. So, no, great summary.
I think that's a great example, and that's also partly discussed in chapter 15, which goes through NFTs. So when you have a hard fork, you know, what are the rights are attached to the NFT? And in chapter 15, there's a suggestion made that terms and conditions should stipulate what rights, how it affects the rights of the holder. So maybe that's something that should be considered.
Yeah. But they're saying that it should be specified in the terms and conditions and not in the source code, like not at the code level.
That's what the suggestion was, but perhaps we could respond to that. Perfect. So moving on, there's also derivative or dependent transfer of title. So the previous slide talked about independent transfer of title. So this is where the party acquiring the right received by transfer a pre-existing interest of another or some lesser interest carves out of the better interest of another. That sounds a bit complicated, but I raised this excerpt from the liability for wrongful interference with chattels. So in the case of dependent acquisition, the party acquiring the right acquires a pre-existing property right. So it's not a new right that's created. It's a pre-existing right. So such an acquisition can occur in one of three ways: by deed, by delivery of sale. Looks like there's one missing. And in each case, the transferee must intend their legal interest to pass to the transferee, or the transferor rather must intend. So in conclusion, a transfer operation that affects a state change, which was also covered last week, is necessary but not a sufficient condition for the transfer of a superior legal title to a crypto token under the law of England and Wales. All right, and there's also, I'm not sure if this was covered last week, I don't think it was. There's a principle called the Nemo-Dat principle. So one cannot give what they do not have. This is the expression that a person cannot transfer a better title to an asset than they have themselves. And it's also codified in the Sale of Goods Act. So I'm not sure if we discussed that question about whether crypto tokens should be classified as goods under sale of good legislation, but that's one of the questions. So yeah.
I don't know that we discussed it in our session, but on Twitter last week there was a bit of a, not so much a storm, but a bit of discussion saying there is a difference between tokens that come to the world by emission or through mining versus tokens that are distributed to raise capital, with the former being more indicative that they are a good or a commodity because it's earned, whereas the latter being more financial in nature and not a good or a service. And so there was discussion to interrogate the use of that as an analogy to explain when something is a good versus when it's a financial product. And but no, it certainly didn't come to any agreement or consensus.
Yeah, well, the consultation paper, I think, concludes that it shouldn't be classified as a good.
All tokens or crypto tokens that meet their proposed third category criterion.
I think the latter one, so crypto tokens that meet that data.
So that, well, in plain language, then that means that the UK is opting to treat them all as commodities and goods. Whereas in the US, it's looking more like, with Gary Gensler's comments, that all of them should be securities. So that is reflective of the UK trying to be friendly.
Interesting. I've copied out the definitions of goods in the respective legislation that was raised in the consultation paper. So Sale of Goods Act, which is very similar to the definition in the Supply of Goods and Services Act. So the definition includes all personal chattels other than things in action and money, in particular goods including emblements, industrial growing crops and things attached to or forming part of the land, and includes an undivided share in goods. And the Consumer Rights Act defines goods as any tangible movable items that include water, gas and electricity. So clearly their crypto tokens don't fit into those definitions from a natural, from a reading of the wording, a simple reading of the wording, because they're not tangible movable items.
But they are intangible movable items, so the definitions may not need that much change.
That's right.
Whereas, you know, to use email accounts, which is one of the previous chapters, it's intangible, but it's not movable because of the terms and conditions of the email providers. They say that only Iris Rad can use the email account that is connected with you. You can't sell that in the public domain for a price.
Nathan, Victoria, do you have any thoughts on this?
Not really. I'm just listening.
No problem. Well, moving on to the consultation questions. Again, I think this question 22 was covered last week. So whether the special defence of good faith purchaser and innocent acquisition rules should apply. I think the answer was in the positive, that they should apply.
Yeah, we did have some discussion on this last week, so I think we can skip through to chapter 14.
Sure, yeah.
Yeah.
There was also 23 and 24, which I think were also covered last week. Perfect. Okay, moving on to chapter 14, linking a crypto token to something else. So the consultation paper makes a distinction between endogenous and exogenous crypto tokens, but it says that such a distinction does not necessarily need to be made. So endogenous crypto tokens are those that are not linked, don't link the external to the crypto token system that the token is a part of. The token itself in that case will constitute the asset of interest or value. Contrast that with exogenous crypto tokens, those that represent something external to the crypto token system. So for example, relationship to an intangible thing, which could be an equity or a debt security or a legal right against someone, contractual debt, or it could be to a tangible thing. So for example, goods or land. Now, some crypto tokens can be linked to other crypto tokens, which can be instantiated within the same crypto token system. It gives the example of the fractional ERC20 tokens issued in connection with a locked NFT or a basket of other crypto tokens. Goes through the examples of how a crypto token can be used merely as a record or register of a thing that's external to the crypto token ecosystem, and that in this scenario, the link between the crypto token and the external thing would likely be evidential only, and the crypto token would not confer any additional legal rights to its holder. So it's purely evidential relationship. And it suggests that this could be established by legislation, which could determine the strength of the evidentiary power of the record and any transfer formalities. Do we have any thoughts on that?
Yeah, I think I agree with the paper's conclusion that it's a helpful distinction, but only for sort of educating yourself and understanding how to get to the facts of the scheme, and that even though they've provided this non-exhaustive list of potential examples of linking, that all of the different types of links mean that really you just need to understand what's going on, regardless of how you characterize it. So even if something is called Bitcoin or Ether, or is a copy of that code, you still need to go and look at how it's been deployed and whether that copy has been upgraded such that the ETH is linked to another crypto token, like, or an intangible asset or a real world asset in the new instantiation of the data structure. So I think it's a helpful chapter. But again, it sort of just goes back to the need to explain it in more plain language on the user interface or a terms and conditions if a person, a lay person, can't go and look at the source code to understand that, like, that evidential or the factual circumstances. That's the fundamental crux that we keep coming down to, like, how much of coding does a person need to understand?
Jenny, do you think it's appropriate to include the type of information as a disclosure within a token, or where do you think that information should be made available, if at all, to a layperson to understand?
I think either through more simple terms and conditions. So you've mentioned even previously, like, those visual or like video terms and conditions. And it's more of a gated approach to you being able to engage further with a blockchain or with a particular token. So once you've looked at the video tutorial, then you can trade, or then you can acquire this NFT, or you can be eligible to participate in the NFT crowd sale.
Okay, so like, for example, like FTX arrangements around the different accounts that they can offer.
Who was that, sorry?
FTX has different training modules that you've got to go through to be able to access different accounts, and different accounts allow you access to different types of products, specifically how much leverage you can actually assume, which makes sense.
Exactly. Yeah, and so you're seeing a lot more gated approaches by the centralized token exchanges, still not by the decentralized exchanges, and still not by a lot of the NFT projects where they don't explain properly, or they don't have Ask Me Anything's AMAs to say, well, we've linked to a video file or an image, we're using IPFS, and this is what that means for your ongoing connection or your actual legal right to ownership of that unique image. And what's not being explained is that link and all of the things that it relies on to cure or to make good ownership. So, you know, as Iris was going through in the previous chapter, all of the things that can defeat or be better title than yours. Well, Amazon and Microsoft may have better title to the image than you do, perhaps in a lot of cases, because if the server hosting fees are not being paid by whoever said they would pay them, then they sit within Microsoft and Amazon. And I'm yet to see a claim from an NFT holder that truly wants to own the original image on one of their hard drives and not for it to be hosted in a cloud server. That's sort of to dumb it down on the strength of your ownership and all of the things in between that you don't necessarily know about, which prevent you from properly having your ownership to the linked asset. But it probably only applies to the intangible linked assets. Real tangible ones, that's its own host of issues around land titles and land title registries, and a transfer of a token needs to be fed back into whatever land titles office is applicable. So I think that all of those regimes will have to be worked through step by step for the nuances of blockchain systems and crypto tokens, if crypto tokens are their own class of property.
Thank you, Joni. I think that kind of feeds into the consultation question. So are there any other types of link between a crypto token and a thing external to the ecosystem that you commonly encounter or use in practice? And perhaps, Nathan, you might have thoughts on this.
Yeah, I was just thinking that the only real like comparisons and issues that can possibly come up there in terms of being external to the chain itself is obviously storage, but also just like the server and the name of the server. And there's been like quite a big like discussion around GoDaddy and then ENS, right? Because they sold the eth.link name, the server name, too early. It's like 800K, and now Maple Finance owns it. And it was a whole discussion because pretty much most of ENS's names are run through eth.link. That's a center of all their names. So that was pretty bad. And it all comes down to relying on an external authority that isn't even blockchain related. So one other thing that was interesting to look at before the merge and when examining a fork was, right, well, if every DeFi protocol is forked, sure, that's fine because it can exist in a fork with the same smart contracts and people work as it used to. But the thing is, who's managing all the websites? No one is, because they're all external. So beyond those few things, I can't really see anything. Well, no, actually not. Every interaction is done externally unless you can code. That's something I've been saying for quite a while now. Unless you can code through smart contracts, I've got no idea how to interact with the blockchain because it isn't in plain English. It isn't in the jargon that we use. It's all in like cryptid words. It makes no sense. So it's heavily reliant on being able to code or using websites.
Yeah, well, and just to even read out the Law Commission's provisional conclusion that market participants should have the flexibility to develop their own legal mechanisms to establish the link between a crypto token and something else, and that normally a thing external to the crypto token ecosystem. As such, they provisionally conclude that no law reform is necessary or desirable further to clarify or specify the method of constituting the link between a crypto token and a linked thing or the legal effects of such a link at this time. And Nathan, your example is poignant because if you don't have legislation, at least at to manage any duplication with the eth.link example for the proper functioning of these systems, then the market may not function if it's blocked up at a very early level. So how could regulation function to unblock and make markets more easily tradable in? Because that's the crux of the eth.link example, isn't it? Or did I interpret that incorrectly? Nathan may not be in a position to respond.
Sorry, no. Yeah. I was just like, I'm on my phone and my phone's not paying well. So yeah, exactly. That's the whole issue. It's just it's that we have two contradicting requirements. One, to be able to code. Actually, no, there's three. One, to be able to code. Two, if you can't code, then you have to use websites. And three, those websites are done by centralized authorities who can do whatever they want, whenever they want, which isn't very it's very, very contradictory to the ethos of crypto and a decentralized net. So it's hard to reconcile all those three main ideas at the same time, and that's where heaps of issues are coming from. Just those three main pillars of what do we do to allow for everyone to be able to use crypto, so to lower the barriers of entry whilst also being decentralized and building at the same time and making it easy for builders without using millions of SDKs.
Yeah, I think it's a tough question to actually answer because I see on the one hand, they're probably trying to say to not bring law in too early so that the market has the freedom to innovate. But on the other hand, the market could benefit by standardization in a sense, or a minimum base standard set by law around how that linking, the things that linking needs to show in order to be legally recognizable as a perfect or a good enough property right, both to the crypto token and the thing that it references or that it links to. And we've been around enough. We've got a few examples under our hats that there probably could be at least some guidance offered in a legal statement form, as they had done with smart contracts already.
Yeah, totally. And I think one other thing worth pointing out is that well, Falcon and I have a great example of just how we've had a problem and we've solved it by mirroring what exists in Web 2 and taking it to Web 3. But there are so many other softwares and areas in Web 2 that are crucial to a business and being profitable or functioning, that we haven't yet adapted into Web 3. And that's, again, where these problems are going to arise, because like even with things like Discord, right? It's another great example, because that's external, and every NFT community pretty much relies on having a Discord. If you create an NFT and don't have a Discord, I doubt that you'll get much traction from whales or big investors, because they look down on it. But then we have the reliance on Discord, and Bored Apes, Yuga Labs have been hacked numerous times, and nouns are hacked, and every single collection is always getting hacked because of this reliance on a third party, which is again required for the collection to take off. So it's also contradicting, because how do we reconcile the need for Discord or a different Web 2 application and the need for safe activity when you're traversing the crypto environment?
Well, I think that's what they're trying to get to in saying it's for the market to solve and to say it clearly in the terms and conditions. So you wouldn't have to go to a Discord for the latest updates. What they would be expecting there is that the market goes to the official website and sees that there's a pop-up and says our terms and conditions are updated, or the third-party service that we're using to store images is under attack. That you go to the website, you don't go to any other things for the updated terms and conditions or the status of things going on. I think that's what they're getting to.
I think that sounds good in theory. It just won't work, because one of the most important features of NFTs, like the one thing, you can debate crypto all the time and NFTs all the time. You can say it's proof of ownership, great, whatever. People don't care about it. But the one thing that you can't dispute is that it's an entry into a community, and that community requires constant conversation. That's the whole point of having a community. Of course, there can be, real life conversations and discussions that are great, but having the ability to chat with people who are into the same things as you, because you both own the same collection, is great. And that's what Discord provides at the moment. So yeah, we can have the big updates on Twitter, which again is the same problem, or on the website, which is still the same problem because they're relying on the web server. But until we can find a way to converse and chat efficiently in a safe way without external reliance, the problem will just keep on arising.
You raise a fantastic point that our legal frameworks don't cope well with community consensus models, where it's distributed, and they want to bring us back to the one central website or the one central legal entity for the source of truth and legal responsibility and liability. And we haven't evolved our legal frameworks to see that there's strength in a community, and for a community to be thriving off each other. So, and that's what you get with the peer, like so many eyes on the code. They can see when something's going wrong. Other people will go in and check it. And you start to build that sense of, oh, we can rely on this news because there's a number of community members that are aware of it, that are checking of it, that are monitoring it. It's not just in the employment team of that centralized entity. And I still don't think that there's enough trust within the legal frameworks as they're written in this new model of community consensus and trust. That's you make a very sagacious point, wise beyond your years point, I think.
Thank you, Joni. I didn't know what that word was. I appreciate the definition afterwards.
Yeah, that's all right. That's all right. Iris or Vic, did you want to say anything else on that question before we move on?
I'm definitely having to look up sagacious. That's a great one, Joni. The only thing I wanted to add is, the law has some really cantankerous experiences trying to actually understand what happens when you need to I don't know, crowdsource advice, expertise. You know, there's precedent for being able to do it. Say, for example, we were talking last week about empanelment of experts to provide support to juries or to judges, where you caucus and you produce expert evidence by way of asking a bunch of people that are experts, what do you think? What's the consensus that can be achieved amongst, you know, this brains trust? And I just don't think that we've got there yet in enabling that type of brains trust to be something that's vested in amorphous, decentralized, pseudonymous community. And this is the cynic in me. I don't think we're ever going to get there from a legal perspective, but I think there's early examples of dispute resolution mechanisms being adopted in DeFi protocols that don't look to, you know, a centralized component of decision making around a dispute matter. The social consensus is considered the more valuable opinion, and so I think that's a bright line or a hopeful moment in how we can see different models of arriving at what is the outcome or what is the truth to be derived from a particular situation.
Yeah, and we have a strong sense of social consensus at the blockchain level. So the chain that is the longest is where most people transact, and there's more validators or nodes supporting that chain. So by social consensus, that's the one that has been picked in the case of a hard fork. But at the application level, when something goes wrong or there's trouble with the link to any external thing, there's not there's not so much of a social consensus on chain. It's, as Nathan points out, it really forms within the Discord.
Yeah, and something also that's really, I think, important to think about, not right now, but in the future, is how we can get game theory to have an impact on DAOs, which sounds kind of obvious because it's how the world works. But Johnny, you mentioned how consensus works and everyone agreeing works at the blockchain level. And yeah, it comes to the idea that the longest chain is the truth. That's everyone agrees is the truth. But because of that, we have a paradox, which is talking about game theory, which is let's say for a miner or for a validator to propose a wrong block, right? Or mine and create a wrong block, there is a loss of computing power, or now it's sort of like the potential that your ETH gets slashed, right? And the benefit of you making up millions of Ethereum to your wallet, right? Or Bitcoin. But the idea is, because it's fake, no one will join onto your block. So if you're looking at the expected value in the long term, you're going to lose money because people won't build in your block, which means you're not contributing to the longest block, the longest chain, which is the truth, which just means that you're losing. So because we have that idea of game theory and behavioral economics at the base layer of consensus, it just always works. Because to any rational person, and therefore a person who's created bots who are also all rational, nothing would ever go wrong because of this fundamental protection that comes from game theory. So if we can find a way to implement that into protocols and DAOs, well, it's just perfect, but hard.
Agree. All right, well, let's try moving on to the next question.
Sure, that's very interesting. I hadn't considered game theory at all in this context. So that was the last question in chapter 14. Now moving on to chapter 15, which is on NFTs. And again, we've touched upon this. I'm sure everyone already knows a lot more about NFTs. So fundamentally, the paper notes that an NFT is a crypto token that is capable of attracting personal property rights in itself, just like any other crypto token. And in particular, NFTs are interesting because they allow us to explore how those rights can coexist alongside other interests, such as intellectual property interests. It specifies that the non-fungible aspect of NFTs is due to the fact that it has a specific token ID that is tracked by the address within the crypto token system that is associated with that particular token ID. So one is not the same as the other because of the token ID. Now, it talks about things that are internal and external to the NFT. So novel situations will arise, for example, where NFTs can include or do include an internal data set as a constituent part in an NFT, or they can be linked to an external data set stored elsewhere. And the idea of control, or alternatively ownership of an NFT, which purports to give rise to external legal rights in relation to that internal or external data set. It also talks about the example of how NFTs can be used in the registration or records. So it notes that NFTs are particularly suited for record keeping or registration because of that specific ID that is associated with an address at the one time. However, it says that this may also give rise to novel issues. So for example, it may be possible for coders to seemingly replicate an NFT, which is called sleep minting, so that it looks like an NFT looks like it came from a particular address. And they give the example of someone who successfully minted a replica of Beeple's the first 5,000 days. Now, from my understanding from reading the consultation paper, it seems that even though it was a replica, you can still establish the fact that it wasn't perfectly identical. So even though it may be possible to seemingly replicate an NFT, I don't know if it's possible to replicate an NFT like 100%.
Yeah, no, I can definitely touch on that. There is no way that an NFT can be perfectly replicated to the extent that every single trace of it, every ID, and the creator looks the same as the original one, because it's all done through RSA, so private and public keys. And unless the only way it could be done would be following the merge. If the fork chain had the same chain ID as the Ethereum main chain, which would allow for transactions to be copied. But before that, there's no way. Yeah, Turo.
Sorry, I'm only 40 minutes late.
Perhaps you have some thoughts on this. So we were discussing about how the fact that NFTs are non-fungible is due to that they have a specific ID that's associated with an address at the one time. However, the digital assets paper gave an example of sleep minting. So where it may be possible to seemingly replicate an NFT. However, Nathan just mentioned that it's not possible to completely replicate an NFT.
Okay.
The focus being though on the address from which it is minted rather than the token ID. Well, both are important, but so that if you go back to the address and try and do a compare to make sure it's a legitimate production from that owner, that you could get confused because they were, I don't know how close they were, but it was designed to fool somebody.
Okay, I love speaking about things that I know nothing about. So I've never heard of sleep minting, but I've been waiting to touch upon my view of the definition of an NFT and the value it actually has. An NFT is nothing more than to define an NFT, you need to define an NFT collection. An NFT collection is an array. That array of objects has an address to identify the collection. Once you identify that collection, the NFT itself is the position in this array that specific NFT has, right? There's absolutely nothing more to it. And then what people do is that they say, well, this position right here has these specific features and it has that specific picture, but all of those are just representations, visual representations, or let's call it human representations, to effectively say, well, this is what we think the value of this position within this array effectively is, right? And then we just reading this thing really quickly, you could have you could create another token, another collection, and then you could create another NFT with the same position in the array, where the representation of the second NFT is very, very similar, if not identical, to the one of the first NFT. They link to the same images, they have exactly the same feature combinations and so forth, but because the addresses but because the description of those NFTs and the position in the array are the same, then you could be mistaken by thinking that one is the same as the other, but they come from two different addresses, right? So
you have to have some sort of verification of like the original owner's address, and a layperson needs to know how to look for or verify that to not suffer the attack, to not suffer a sleep minting attack.
Correct. And the reason why I've been waiting so long to say this is also because we always talk about what the value of the NFT is, or what the properties of the NFT is, and we talk about NFTs as an actual concept, right? But it's almost like trying to normalize a concept where the concept is so generic, it's actually just a position within an array, that the conversation is meaningless, right? It's what that position within the array represents in real world terms or in utility terms that really drives the conversation of what the NFT actually is, which means that an NFT could be absolutely anything until you define what that is, right? So, having that generic NFT conversation is often a waste of time.
Yeah, it might get harder in the context where it's no longer collections, unless you consider a land registry as its own collection.
Yeah, you would.
Yeah.
You would.
All right, and then the next case, which we hadn't got to yet, was forking. Did you want to pick back up from there, Iris?
Absolutely. So it gives another example of forking. So when one blockchain forks into two, and states that there would need to be some determinant to decide the NFT that is considered to be the authoritative record. So for example, this could be done through sophisticated terms and conditions. Gives example of the variable terms and conditions, which recognize that a hard fork could lead to the aggregate number of the collectibles being increased, which could have an adverse effect on the value of each collectible or the aggregate value of the total collectibles. So the value after the fork is different to the value before the fork.
But this is confusing to me, because I mean, this is the case we've got in litigation in federal court, but not in relation to NFT collectibles, in relation to just ETH and ETC. The crux of the legal argument is not which is the authoritative record in the terms that the Commissioner of Taxation poses it, which is the original and which is the new. And but you could have different ways of characterizing new and old, defunct or recovered. There's a number of different ways in which you describe why there might be a hard fork. But really, with what we saw with Ethereum, that was where social consensus prevailed and said, we support the Ethereum chain. So in the context of NFTs and collectibles, my assumption would be, but I know it would be very controversial, is that only the collectibles on the social consensus chain have any value. If you want to trade in what's on the non-social consensus chain, you do that at your own risk, knowing that that's not the correct legal record. And that goes back to the earlier chapters about the state of the ledger is the correct factual record, but not the legal record. And in hard forks, we need to understand which blockchain post hard fork is the correct factual record to support the legal analysis. That's the very hard question.
Does it actually make sense to try to create a legal framework as a catch-all in these scenarios, or shouldn't there just be a requirement that it depends on what the creators of the collection actually state. Like, this is part of the terms and conditions, right?
Mm. Well, no, Rareable is a platform and it's sort of covering its base. This is not a statement by anyone or a collective of the artists producing these collections. It's the platform's statement about managing their own financial risk exposure. And so it would have been more helpful for the Law Commission to try and extract or find any NFT collection statement about their position pre and post a hard fork.
Okay, but okay, so I would argue then that it's not the responsibility of Rareable to do that. I would argue that Rareable, like for example, Classic ETH and ETH, as we know it, they're two chains, and I could just provide a market on both chains and let people decide which one of these they want to buy.
But wait, in the context of NFTs, do you mean you do half of the collection on Ethereum and half on ETH Classic?
No. You when you fork the chain, you don't do half. You get double the supply, right? So it's two different collections. They get cloned, right?
But which is the? Do you think that there should be an authoritative or like
dominant,
just one collection?
No, I don't think that there should be an authoritative one. I think that there should be an authoritative one only when, okay, so let's say that, let's view real world as one chain and then Ethereum as another chain. Then if I have an asset in real world that I have linked to an asset on chain, and this asset on chain gets cloned, then we need to decide which one of these two assets is the actual representation of this unique real world asset. Then it's a problem. But if I have two pictures that get cloned, right, then there is actually just a clone. I mean, it's almost like saying I have a Gucci bag, and then this Gucci bag gets copied into another Gucci bag. They look completely the same. They still exist, right? And they can be traded, but one of them has emotional value, the other one perhaps has less emotional value.
But I think you're still saying that the real Gucci bag is on the social consensus chain.
I'm saying that I don't think that we need to have a legal definition for what the real is.
If you don't, the market may not invest even at the outset in the Gucci bag on the Ethereum chain, because they won't be able to have any sort of certainty that their original unique right is maintained and that the value accrues to that main right.
So I would argue that what defines a Gucci original is that the creator of the Gucci collection says this is the original one in the event of a fork, which then goes down to the T's and C's. Right, in the event of a fork, then Gucci says that they will continue to support the one that follows social consensus or yada, yada, yada. Or maybe they actually say, no, we are sticking to proof of work if that is the second one because X, Y, and Z reason.
Yeah, and we saw this around the centralized exchanges, but in 2016, at the time of the ETH Classic fork, they said that they didn't want to decide for the community, so a lot of them still listed ETC and ETH, and so they let the market decide. But in this case, the collectors, I don't has anyone on this call seen them make a statement to their communities about which they will treat as the authoritative collection post merge? No. They've just been silent.
Sorry, which question is this?
Oh, any collection. So, so Kevin Rose of Moonbirds or any of the
Yuga Labs just said the licensing will only be available and promised to those who are looking at the NFTs on proof of stake.
On the social consensus chain.
I want to jump off. I just want to mention one thing for a discussion. How about like punks, right? Because V1 punks had a bug, and everyone was like, that's pretty problematic. And then the second one came about. And this is different because there's no fork, but there is still social consensus. There's still a consensus that the one that are currently being backed by then it was Lava Labs, but now Yuga Labs is a real collection. But regardless of that, V1 still has a lot of value in this. It's trading for like a floor price of 4.58. But there's no licensing for that because Yuga Labs have only now said that Punks applies strictly to V2. I don't know. It's interesting. I've got to jump off, but I'm going to follow up on that next week and see what everyone thinks. Thanks a lot, guys.
Thanks, Nathan. Bye.
Yeah, bye.
I think that's a really good example. That's a fantastic example that just shows that people will give value to whatever it is that they want to give value to. And law can't, or should law really jump in and say that you can't give value to something that even the creator says should be valueless.
But if we look at it from the value side, Lava Labs and now Yuga Labs have issued V2 with licensing, but V1 was effectively open source with a bug. And so the value side is one thing. I as a market participant, despite V1 having a bug, I want to support the original. I think that that's going to go up in value more. Therefore, I will buy V1 rather than V2. And that's my decision to make. But if now all of a sudden it turns and there's liability because of that bug and I lose all of my assets, that's also something that that there's no central party, that there's no person that I can blame or that should have warned me for that. It's very much in my do my own research territory and take my own risks. So there's one perspective that is the value and the other which is the ongoing exposure to liability or loss.
Doesn't that automatically fall into the terms and conditions and the disclaimers that are?
If there is terms and conditions, like V1, I don't think had any licensing or T's and C's, nor do we know the artist. I don't think. Correct me if I'm wrong there. Vic, I think you had your hand up.
Yeah, sorry guys, I feel like a bit of a dork. I want to just understand Nathan's points. So he was explaining that version 1 Punks had a bug and then version 2's didn't carry that bug, and then licensing terms determined that V2 were legitimate NFTs. Is that correct?
It's that Lava Labs and then Yuga Labs, because there was an acquisition in between, they decided to redeploy the contracts without the bug. So same artwork, but safer contracts and with licensing conditions. And then I think they subsequently changed the licensing conditions. So it's just an interesting fact pattern around artwork and an NFT collection that has started native, if I can call it that, then was acquired, and then the terms and conditions have subsequently changed. And that's, I guess the takeaway is that's the risk that you take on as a market participant investing in these sorts of assets.
Yeah.
But what, like, to get to certainty of property rights and the causes of action and remedies around them when those property rights are harmed, that's what the UK Law Commission is trying to do, so that more people feel safer to invest in this class of assets or to use it to manage their registries, such as for real world land titles.
So I guess that there's a difference also in terms of rights. And again, I don't know the detail here, right? So I'm going out on a limb, but I'm guessing that there's a difference between me purchasing a property and actually owning that property, and me purchasing a property that is defective and somebody being, liable for the the issue that the property effectively comes with, right? So if I pile into an NFT that has a bug, I still own that NFT with the bug. And arguably, the NFT was open source, so it's kind of like it is what it says on the tin, right? I still own it.
If you know how to read the tin.
Yes, I know. But you still own it. If that makes a difference in the in the argument.
Yeah, well, I think you need to say you own it and you remain liable for harm that comes from your ownership of something or
That's the point
exposed.
that you're making. Oh, sorry, Jenny, I jumped in inappropriately.
Right.
Arturo, are you making the point that even if you purchase something and it's defective, by virtue of purchasing a second V2 or something, it doesn't extinguish V1 ownership? But also, what happens if you're able to burn a V1? Let's say you've got another hypothetical. You've got a defective V1 NFT, and to correct that defective one, you can issue a corrected one, a V2, using a ban mechanism for the V1s.
Yeah. That's a good point. That I think that would be the diligent way for let's call that a collection curator to manage a scenario like that. You'd want to have the first one burnt, because otherwise you potentially end up with it's almost like a stock split where both stocks are potentially worth the same, so you're just doubling your value. And I mean, who's to say that that's wrong? But maybe you don't want that, so you'd burn one and mint another one. But I think that point still goes down to the liability that the curator effectively has in terms of what is expected of their actions, versus in a scenario where no T's and C's exist, the curator is completely anonymized, and then try to figure out who actually owns what or what should happen. I think that those are two different conversations, right?
Yeah, no, we're going into our own rabbit hole, and I know we're at time, so I might hand back to Iris to close this part off and then lead us into topics of discussion for next week.
Yep, absolutely. Thank you. I think this has already been covered, but this is a consultation question. So do you consider there are any specific legal issues relating to NFTs that would require different treatment from other crypto tokens under the law? Sounds like the prevailing answer is no.
Well, maybe.
I think that it's really interesting when you're able to change off-chain data records that relate to an NFT, and then also see how Animoca has adopted a fairly Animoca favorable purchaser unfavorable approach to licensing, and some of the terms that you can now see in the collections that they're producing. And I mean, while the former I think is really interesting from the perspective of basically what you're purchasing can change over time at the discretion of the producer of the NFT. If you're allowing for change and updating of data records, that I think poses a specific legal issue, because ultimately you're not buying a static piece of property, you're buying something that is changeable. So what is it that you're actually purchasing? Is there certainty in contract for what you're purchasing? And I'll leave that one with Joni as well. What do you think about that?
Well, just to say, if it is a more traditional form of contracting, usually the contract says these are the licensing terms. Any amendments are subject to agreement in writing between the parties, and it's really just a 1 and a 2. But when you've got an artist that has a contract with many, and it's impossible or impracticable to have an agreement between all parties. Maybe you get to majority by a vote, but we're seeing these licensing terms be implemented or be changed quite unilaterally without any negotiation. It's more of a surprise. Hey, we did this. And so it to me, it's really jumping far ahead from the traditional contractual bargain and how those things are amended to these new states. And that's, the market doesn't like those sorts of surprises. And so it may be only a certain type of investor that is willing to put their money and their wealth subject to that kind of risk, that unilateral change risk.
May I then say that perhaps the correct way of seeing value in a generic NFT is more akin to a membership, because quite technically that is effectively what you're getting. You're getting a membership in an array in memory of the blockchain, right? And then this membership is represented in different ways, and you gamify it by adding features and so forth. But in reality, that's all you actually own, if you can use the word own.
I like that. I really like that formulation of what an NFT is, accurate, because it allows that alacrity in what it actually represents, which I think is where we are ending up. Alacrity in terms of what actually attaches to it, whether it's a specific artwork, whether that artwork changes over time, whether and the licensing arrangements that are afforded in relation to the use of that artwork. Just using the example of artwork, of course, knowing that NFTs can be many other things. I think it also speaks to the community element of it as well, membership and community. Not merely positioning in an array as well, or thinking about the more social elements of the social socio-techno thing that it is.
Yeah.
All right, we might need to wrap up here.
Yep. Yeah, thank you very much, everyone. So next week we'll go through the final chapters, which are 16 to 19.
Home stretch.
It was awesome.
Thanks.
Thank you so much, guys.
Bye, everyone.
Bye, everyone.